very much for the invitation. It's yeah, nice to be thought of as a trailblazer, but I suppose we both are for hosting the lecture in this way. So it's very nice to see so many of you on this call. And as was said, the title of this lecture is a Public Health Approach to Equality Law. And what I hope to do is have you think about whether it's possible to take a more holistic approach to tackling discrimination that includes the law, but also goes beyond it. And my format for doing that is to think about how public health specialists go about tackling viruses. So I wrote about this a couple of years ago, and at that time when I wrote about it, the model that I was working on was Ebola. So I was looking at how public health specialists tackled Ebola during the 2014 outbreak in West Africa. But of course now we have an example that is much closer to home. So my examples will be based upon COVID-19 and the interventions that we are seeing in this country and all around the world, really. I'm really sorry that we can't meet in person. I was fortunate to attend some of these lectures last year. So while I speak, I will be imagining the ambience of the Law Society, that lovely room upstairs in the Law Society where we met in 2019. And I hope that one day we will be able to meet again in person. So I have some slides. I will now try to share them. There we go. This should work. So I hope that you can all see that. There we go. So as was said, the title of this talk is A Public Health Approach to Equality Law. And I think this, so I'm offering this, I'm suggesting this as a way to take a more systemic approach to tackling discrimination. And the image there you can see was taken from events this summer, the Black Lives Matters movements, which erupted all around the world, really, in response to the killing of George Floyd by a police officer, just one of a number of police killings. And I use this image because I think when we see such things, an armed policeman holding some kind of rifle, I don't know exactly what kind of machine gun it is, but at a man with a child on his shoulder, I think that we need to, there's something more going wrong here that we need to think about addressing through law. I don't think when we see such events, we can blame individuals. So I think we need to go beyond a straightforward behavioural approach to tackling discrimination and think more about the systems that are perhaps supporting discrimination. So the structure for this talk is that I'll first of all start by suggesting some ideas on what equality law is for. Then I'll give a brief overview of the way in which equality law has developed in England and Wales, and then look at its impact. And that really is just to give a background to, or an introduction to the public health approach and what difference I think this can actually make. So thinking then about what equality law is for, and I'll just highlight here a couple of academic ideas, including my own. So Deborah Hellman, who is an American academic, she argues that equality law, the purpose of equality law is to tackle demeaning distinctions. So one of the examples that she gives is that a sign that says bathroom men only is not demeaning when we find it on a bathroom door, but when we see that on a courtroom door, that of course is demeaning. So the purpose of equality law is to tackle distinctions such as a sign that says men only on a courtroom door. Taran Kaitan, who is a British academic, he emphasizes a different purpose for equality law. His emphasis is on autonomy and the rights of individuals to make free choices. So his argument is that the purpose of equality law is to protect autonomy, ensuring that people have the freedom to make the choices that are best for them between options that they value. What I'm going to suggest is that equality law goes beyond that and is actually to tackle stigmatization. And in tackling stigmatization, what I'm trying to emphasize there is social power. So equality law is not just there for individual to enable individuals to enjoy their rights, but equality law also should exist to ensure that social power cannot be used to dehumanize people and therefore make them susceptible to discrimination. So some overarching ideas for you there that I would be keen to gather your views on during the Q&A as to what equality law is for. So moving on then to think about the evolution of the use of law to tackle discrimination in England and Wales. Prior to 1965, which was when the first anti-discrimination statute was introduced, there was a significant reluctance to create a law specifically to tackle discrimination. And at that time, the discussion was really focusing on racial discrimination. So during the discussions in Parliament, it was very clear and it was accepted that there was no remedy in law for discrimination. So it was described as a mischief and a defect for which the common law did not provide. There were many attempts in the 1950s to introduce private members' bills to tackle what was then called the colour bar, but none of these were successful because there was a general reluctance to use law to tread upon what was seen as common law rights. So rights such as the right to employ or to fire whomsoever the employer chose, or the right to provide housing according to individual preferences. This only really changed with, well, there are a number of factors that caused this to change, but one important factor was international law and the adoption of the International Convention for the Elimination of All Forms of Racial Discrimination in 1964. So that was that the ICERD provides a backdrop to the decision to actually create the first anti-discrimination law, which was the Race Relations Act of 1965 in England and Wales. So since then, we've had a number of iterations of anti-racial discrimination law. So you can see here the 1965 Act on the far left. That act was replaced in 1968 by a second version, which included prohibition on racial discrimination in employment. And then in 1976, a more substantial act was introduced, which was, of course, then brought into the Equality Act, which we now have since 2010. So we now have a significant and mature, I would say, framework of law to tackle racial discrimination. But now I want to think about the progress, and I'm going to stay focused on race, and so think about what the impact has been of these bodies, these statutes and the body of case law over the last 50 years. So in 2015 and 2018, we had the 50th anniversaries of the Race Relations Act 1965 and 1968. In 2017, there were a number of surveys and investigations into race relations in Britain. One of those was the McGregor-Smith report, which looked at race and employment. And one of the conclusions of this report was that although 14% of the working age population in the United Kingdom is Black, the experiences of this proportion of the population is predominantly negative. So the McGregor-Smith report concluded that there continue to be structural and historical bias in the employment, in the labour market. A second report was produced by David Lammy, who conducted a survey of the criminal justice system. And his conclusion was that there was still a significant overrepresentation in all areas of the criminal justice system of young Black men. Now, in 2003, there was a very shocking statistic provided in a report by the then Commission for Racial Equality, which suggested that there were more men in prison in this country, more young Black men in prison in this country than at university. I'm not sure if that is the case, but that's something that should really, if that is the case, that should give us a significant pause for thought. Then, of course, there was the race audit conducted by the Cabinet, which one of its conclusions was that white people are still much more likely to own their own homes and have jobs than people from ethnic minorities, which I just find a quite incredible result, really, a quite incredible finding, given more than 2 generations of anti-racial discrimination law. And then finally, looking at my own sector, academia, the trade unions have been quite active in conducting reports. And one report by the Trade Union Congress on racism said that more than 1/3 of all Black and minority ethnic workers in the sector report bullying, abuse, or racial discrimination by their employer. Some trade union reports also mention that there is harassment by co-workers, and the Equalities and Human Rights Commission more recently has released a report looking at racial harassment of students, of Black and minority ethnic students by other students. So my next question then is why there has been such limited progress. And this was really the question that took me into thinking about the public health approach. So my conclusion as to why there has been limited progress was that this can be traced to the individualism that is inherent in the legal approach to tackle racial discrimination, but actually discrimination in general. So I argue that our legal approach to discrimination is very much focused on individual attributes. So either our sex or our skin color or our age, our religious belief, etc. And often that is simply not the way in which discrimination is experienced. So one of the other things I write a lot about is intersectional discrimination. And one of the things that the law has in the past forced individuals to do is choose between one attribute or the other. Now, more often than not, this is quite a practical choice. So individuals will perhaps choose the ground which they feel is most likely to lead to a successful outcome. So I think that's one weakness of the current approach to tackling discrimination. A second weakness is, I think, the way in which the law creates or focuses on an individual victim and an individual complainant, which imposes quite a significant burden on the complainant, who has to find their own resources. And when I say resources, I'm referring not just to financial resources, but also perhaps character resources to bring a complaint against an organisation, perhaps an organisation within which they will still have to work. So it's a very challenging scenario within which the individual victim or complainant has to bring their case. Having done that, even if they win, it's questionable what they do win, because often you'll find those who bring cases of discrimination may have to leave their job, and they may find it difficult to find another. The third limitation, I think, is the fact that when an individual does bring a case, if they are successful, then actually they are only successful against a single organisation or a single individual. But that doesn't stop the individual or the organisation from treating another person in exactly the same way. So to summarise, I think a significant limitation or a significant reason for the limited progress of our equality laws is this individualism that is inherent in the way in which we tackle discrimination. So my suggestion is that we think about discrimination in a more holistic way. And the analogy I make, and I've written about this in quite a few places, is that we should think about discrimination as a virus, as for example, COVID-19. There are some similarities. I'm not going to try to convince you that racism is, or discrimination is exactly like a virus. But for example, some similarities are that both discrimination and COVID-19 are invisible. They pass unseen from person to person. Both can maim and kill. I've already mentioned George Floyd, but there are many other examples. And both can leave survivors with effects that stay with them for the rest of their life. So we're hearing more and more about what's called long COVID. And we know that the experience of discrimination doesn't end with a successful or an unsuccessful litigation. So if we think about discrimination as a virus, then perhaps we can start to think about the way in which we tackle discrimination from a public health approach. And this, I argue, would help us to take a more holistic approach. So we wouldn't just focus on action at the individual level, but we would also think about taking more action more at the social level or at an environmental level, as we are seeing actually in relation to the way in which COVID-19 is being tackled. One advantage of doing that is that then we would then think about positive action as a norm rather than as an exception. And in thinking about positive action as a norm, we would then be more in a better position to undertake systemic change. So moving on then to look at that in more detail, this idea of tackling discrimination as a virus can be broken down into taking action to break the chain of infection. So this is a diagram, as you can see at the bottom there, that is created by healthcare professionals to help them think in a more detailed way about the action that needs to be taken to break the chain of infection of a virus. So I'll go through this diagram and then I will apply it to discrimination, and in particular race discrimination. So if we start with the top left-hand corner, I'm sorry, if we start with in the middle actually, the infectious agent. So the infectious agent can be a number of things. It can be bacteria, it can be a parasite, or as in the case of COVID-19, it can be a virus. So the infectious agent is the thing that causes the illness. And the action that needs to be taken to tackle the infectious agent begins with diagnosis, and sometimes the infectious agent can be treated simply with antibiotics. Beyond the infectious agent, in order to break the chain of infection, public health professionals then need to identify the reservoir, which is the place where the infectious agent, let's say a virus, as with COVID-19, where the virus actually festers, where it grows. This can be a surface, it can be in animals, it can be in water, it can be in soil, or it can be in people, as with COVID-19. So the action that is needed to break the chain of infection in relation to the reservoir is mainly cleaning, so sterilization, disinfection, and sometimes pest control when we're talking about animals. The next link in this chain of infection is the portal of exit, or the way in which the virus leaves the reservoir. So this can be through open wounds, it can be through body fluids, or it can be through droplets. As we know now in relation to COVID-19, it's often spread in conversation, so through sputum when we speak. So the action that would need to be taken to prevent the virus from leaving the reservoir can include improving hand hygiene, which is why we're all instructed to wash our hands regularly. It can include wearing face masks. It can include better waste control. The next link in the chain of infection is thinking about the mode of transmission. And this can include contact with surfaces, it can include things that we eat, or even indeed things that we inhale. So there again, the action that we would need to break the chain would include hand hygiene, would include protective equipment, improved food safety, improved cleanliness, sterilization, isolation, as we are mandated to do if we contract COVID-19, and also social distancing. And then you have the portal of entry, which can be broken skin, it can be the nose, it can be mucus, and again, the action to break the chain in relation to the portal of entry is undertaking hand hygiene or first aid or maintaining a social distance of 2 meters. And then finally, to break the chain of infection, public health professionals try to identify the susceptible host. So the susceptible host is any person who has a prevalence to contract this infection. And the action that is taken there would be immunization or even simply education. So I'm not suggesting that all of these types of actions would be things that we can undertake to tackle discrimination. But what I'm suggesting is that by analogy, we can think in a more nuanced and detailed way about how we tackle discrimination. So my next slide will be looking at how that translates into tackling discrimination. So what, for example, would the infectious agent be in relation to discrimination? Well, it could be either words or it could be images. It could be that the virus or the infectious agent can be words and images that are included as well as those that are omitted. Thinking about the reservoir or the place where the virus grows, what could that be in relation to discrimination? Perhaps it could be an educational curricula or television scheduling that contains little or no contribution from Black and minority ethnic experts or scholars. The portal of exit in relation to discrimination could be practices and policies For example, those that create racially homogeneous institutions or degree awarding gaps. If we want to think about the way in which the infection spreads in relation to discrimination, this could be either direct or indirectly from person to person or via social media. If we think about the portal of entry, this could be multiple. For example, it could be visual, such as the prevalence of images of Black men as criminals rather than as judges, entrepreneurs, or astronauts. And if we think about the susceptible host, well, perhaps this could be individuals who haven't conducted any equality training, or it could be organizations that haven't introduced any anti-racist or equality policies. The absence of these might indeed increase the susceptibility to racist ideas. So really, I suppose, what thinking about discrimination along the lines of a chain of intervention helps us to do is diagnose. But once we've diagnosed discrimination, we then need to think about the action that we need to take. And in my last few slides, I want to think about what that would mean for legal educators and for legal practitioners. So if I start then with legal educators, I want to suggest that action that could be taken includes things such as widening participation, so ensuring that there is a critical mass of Black, minority ethnic students in the student body, but also thinking about representation amongst academics and amongst professional services staff in the institution. It would could also include thinking about ways in which the curriculum could be decolonized, so ways in which the Eurocentrism of the curriculum could be reduced through including more works, more scholarship from beyond the traditional Anglo-European sphere. It could also include taking action to make the organizational vision more inclusive. So one thing in the introduction, my role at UCL in chairing the investigation into the history of eugenics there has resulted in a renaming of spaces. So that's what can be done by legal educators or educators in general. In relation to legal practitioners, what we could do there is perhaps think more about the way in which we can use existing legal tools. So for example, the Equality Act already contains provisions on positive action. One thing that we can do is think of positive action then more as a norm rather than as an exception, and encourage its use amongst organizations. So I'm aware that the light is fading very rapidly around me. I hope that you can still see me. I might just dive out for 1 second to put the lamp on. I'll be back in 1 second. Sorry about that. I forgot it was winter. Right, so going back to positive action. As I said, the Equality Act does already include provisions that would help us to take a more holistic approach to tackling discrimination. We simply need to emphasize them more. So at the moment, positive action is seen as an exception to the more individual remedy for discrimination. But if we think about discrimination as a virus, then undertaking more collective action would become a norm. So section 158 of the Equality Act does allow, it provides a general framework for positive action. And I've given you the text of section 158 on the screen. So it allows a person, if they reasonably think that persons sharing a protected characteristic suffer a disadvantage, or that persons sharing a protected characteristic have different needs, or that persons sharing a protected characteristic have a disproportionately low rate of participation in an activity, then it is lawful to take action, proportionate action, to enable or encourage persons with the PC to overcome the disadvantage, or to meet those different needs, or to enable and encourage persons sharing the protected characteristic to participate. So this provision already exists in the Equality Act. So there wouldn't actually need to be any legal revision to take a more holistic approach to tackling, or a public health approach to tackling discrimination. The legal provision is already there. And Section 159 refers specifically to recruitment and promotion. So again, it says that persons sharing, if a person, an employer, reasonably thinks that persons sharing a protected characteristic suffer a disadvantage connected to the characteristic, or have a disproportionately low participation in an activity, then the Equality Act allows the person, the employer, to take action to overcome that disadvantage, minimize that disadvantage, or enable greater participation in that activity. And the Act specifies that recruitment covers employment, which can be full-time or part-time or fixed term. It covers partnerships, membership of law firms, pupillage and tenancy in chambers, appointment to public office, and employment services such as agency services. So there is already scope for taking a public health approach to tackling discrimination in the Equality Act. And then, of course, there is the public sector equality duty in Section 149 of the Equality Act. Now, this is used more regularly, but what I wanted to highlight is that there are 3 sections to this obligation to have due regard. The first is the elimination of discrimination, harassment, and victimization. The second, which is the one most used, is the advancement of equality of opportunity. But here I want to highlight the third, which is the obligation to foster good relations between persons who share a relevant protected characteristic and persons without that characteristic. So this, for example, could be used to tackle discrimination in what I called the reservoir in my analogy, so the place where the virus grows. So this could be used to enable quite more radical action in relation to developing educational curricula, for example, or developing programming schedules, or indeed developing a more diverse body in the media. This second half of the slide here is also taken from Section 149, and it develops what is meant by the idea of giving due regard to the need to advance equality of opportunity. Now, one thing that could be done, and this is a suggestion for legal reform, is that more detailed guidance is given in relation to that third section, so fostering good relations. And this could be very similar to the guidance that is given in Section 3 for Part B, for Section 1, Part B. So whereas Section 1, Part B, whereas it says in Section 3 that involving due regard to the need to advance equality of opportunity involves in particular the need to remove or minimize disadvantages, that could be replaced by a need to remove and minimize stereotypes in order to foster good relations. where it says that having due regard to advancing equality of opportunity, regard must be paid to the need to take steps to meet the needs of persons who share a relevant PC. In relation to fostering good relations, that could mean or call for the need to develop new processes for study, programming, and publishing. And where the need to advance equality of opportunity includes the need to encourage persons with a relevant PC to participate in public life. In relation to fostering good relations, that could include a call for the promotion of diversity and inclusion at all levels of particular organizations. So, in other words, to summarize, from a public health approach, there are perhaps 4 key lessons for tackling discrimination. The first would require identification of the chain of infection and then the determination of action to break the chain. The second would require a genuine commitment to change. The third would be the need to create a multi-level and unified action plan. And the fourth key lesson would be to ensure some kind of coordination and cooperation with international bodies. So that's my that's the final point I wanted to make in this talk. The ideas that I've discussed come from a book I published a few years ago, Discrimination, Stigma. So if you want to read some more about these ideas, that would be the place to find some more ideas. And I'll stop there. And if you have any questions, I'll be happy to take them. Thank you for your attention. So I'll now stop sharing my screen.
Thank you very much, Iyiola, for that really thought-provoking talk, which I suspect has brought not only a new perspective to the way that we look at tackling discrimination, but also has provided one of the clearest exposition of how the virus spreads and how we can deal with it than most of us have seen in all of the coverage on television and by politicians. So I think you've achieved a double impact there. So can we have some questions? I can't see any hands raised. Would anybody like to ask a question?
I'm really sorry about the lighting. I'm not sure what I can do about it at the moment.
But I think you're looking marvellously mysterious, if I may say so. I'm going to ask Seema Saida to ask a question.
Thank you very much. Can you hear me okay?
Yes.
Thank you very much for that very, very interesting talk, and on a topic area that I think very much needs to be discussed and talked about, especially in the current political climate. I just wanted to ask actually about the political climate. I think when we have a Prime Minister who has referred to Black people as pickaninnies and watermelons, and a Home Secretary who wants to put migrants on islands, it's very difficult to envision legislative changes that will actually create the change, the systemic change that we need. I feel like the impetus to change to the society we live in needs to come from a broader social campaign, and I feel like we're sort of cycling backwards with the political climate. So as well as recommendations for political change, how can we get to a place where these changes are actually going to be implemented? Because I don't think it's going to come from central government.
Thank you for that very good question. So one of the things that I really wanted to achieve in these ideas is trying to find a way to make the changes without having to rely so much on government, which is why I wanted to highlight those provisions that already exist in the Equality Act. So sections 158 and 159 are already there. Section 149 is already there. The difference needs to be in the way in which we use them, or the way in which practitioners use them, and the way in which we, as academics, teach our students about them. So we don't have to rely on governmental change or governmental intervention. We can do this just by changing the way in which we look at the tools that already exist.
Thank you. What about Leonardo Orasnovich?
Thank you very much. I'm a barrister, practicing barrister. I'm working in the Caribbean on human rights. So the topic is very, very interesting, and I really appreciate your thoughts, sharing your thoughts about how to tackle discrimination. There was a point at which you suggested that our agenda may be a little bit too Eurocentral. And the work I've been doing in the Caribbean is sort of raising a bit of concern about that point, because I'm based in the Cayman Islands, which in itself is part of the UK, it's a British overseas territories. We have had very recently very important people influential in the politics of the jurisdiction calling for the hanging and stoning to death of gay people on the island. So how is that reverting the Eurocentrism when it comes to human rights? From your perspective, is going to prevent from the expanding of the virus of discrimination, particularly on sexual orientation in this case, from the perimeters of the metropolis into the metropolis?
Sorry, can you repeat that? You broke out slightly.
How is that your idea of being less Eurocentral is going to help to prevent the expansion, the contagious effect of the virus of discrimination, in this particular case, sexual orientation, from the peripheria of the metropolis into, this case, the United Kingdom, for instance, given that the example I gave is an overseas territory?
Oh, so I think, let me just try to summarize your question so that I can try to answer it properly. How does the analogy prevent an infection from the metropolis to the margins, or vice versa?
The other way around, because the example I was giving you is the Cayman Islands being an overseas territory of the UK, and the same happens with other Caribbean overseas territory, the BVI, Turks and Caicos, Montserrat, Anguilla. They are very extremely homophobic territories. The British Caribbean in itself is a very, very homophobic region in the American continent, rather unique, I would say, in relation to the rest of the American continent, from Canada to Argentina. So in your suggestion that we have a very Eurocentral position, that we need to try to be more inclusive, something that in other circumstances I would tend to agree, when it comes to human rights, how is that we are going to prevent the contagious effect from the peripheria, from the overseas territories or the Caribbean, let's say, into Europe, of these homophobic discourses?
Right, well, I think that one of the other things I mentioned was education. I think that's the key answer there. It would require a greater inclusion of perspectives in education curricula, in not just in Europe, but also in the Caribbean. I don't think that's the kind, we would just need to rely on law to address that. That would be the renewal, if you like, of scholarship at the university level as well as at the school level.
Thank you.
Thank you. Francesco Del Balzo.
Thank you, Master. My question is quite a general one. I always felt that the word tolerance and tolerant have always been used when approaching the broad concepts of equality. It is not uncommon to hear someone proudly describing himself or herself as tolerant when it comes to E&D issues. I would be delighted to hear Professor Solanke's view about the relationship that can be found, if any, between tolerance and real equality. I always felt that the word tolerance is somehow intimately in contradiction with the real social equality, since tolerance always implies something negative that must be borne somehow. This in turn suggests me that a tolerant person's attitude toward a type of diversity is at least tainted by a negative approach or attitude toward that. I feel that the concept is a legal one, technically speaking. We can say that the stage of tolerance is somehow midway between repression, the state of repression, and the state of enjoyment of full legal rights. This is what's happened, for example, with workers' rights to strike. More in general, we can say tolerance is directed to those who are considered by the powers half.
Francesco, I think you keep breaking up, so I'm going to ask Professor Solanke to answer your question. I think we've got the gist of it. Thank you.
Sorry, Francesco, you did break up towards the end there, but I think I did understand your question, and it's a very good question. So it's something I write about in my book, this idea that actually the way in which we have designed anti-discrimination law in general seems to suggest that those who suffer discrimination have possessed some kind of attribute that is actually wrong in some way or deviant in some way. So the wrong skin color or the wrong sex or being wheelchair bound or not being able to see, but there is an inherent defect. But because the individual hasn't chosen that, then the law will offer protection from any harms arising from that attribute. And I think that perhaps touches upon what you are saying with tolerance. So because it's really, I think it stems from this idea of immutability, which is the guiding logic, I think, for our development of anti-discrimination law. So the idea that law will protect us when we suffer detriment based upon attributes that we haven't chosen. But what the law then does is, in a way, subtly support the idea that these attributes are actually wrong. But because we haven't chosen them, we should be forgiven for having them. And that, I think, also undermines, as you're saying, a true sense of equality in anti-discrimination law. So one of my other arguments is to say that we need to move away from the logic of immutability and think more about stigma and stigmatization. Because what stigma does is shift the focus from being on the attribute itself to being on the meaning given to that attribute by society. And then I think equality law can move away from this double-edged idea of tolerance. I hope that answers your question.
Yes, thank you. I think we'll take another couple of questions. I'm going to ask Natalie Walker.
Hi, thank you for choosing me, Master. My question to Professor Solanke is: do you think that because we've never had a leader of color, that puts the situation at a disadvantage, to say what it is, in America? Because if you look at the discrimination of women didn't gain true equality in this country until after Margaret Thatcher was Prime Minister.
That's a very interesting question. I'm not sure, to be honest. I don't know that Margaret Thatcher would have described herself as a pioneer for women. So that might have just been coincidence that she was the Prime Minister when a number of significant changes were made. That might have had more to do with developments in European Union law, where in fact there were not many women. So it's hard to say. I don't know that in relation to race it would it would really make a huge difference if we had a Black or Asian or minority ethnic prime minister, because remember, in democracies, you work with a parliament, so it's more important to have somebody who can pull somebody along with them. Now, of course, it might be that a person who comes from a Black, Asian, and minority ethnic background might have more of a commitment to particular types of policies, particular types of actions, but then they might not be able to pull people along with them. So take, for example, the mayor in Bristol, who has struggled for years and argued for years that the Coulson statue should be brought down. Obviously, that was a very personal issue for him. He felt very strongly and passionately about that, but he couldn't get agreement. So sometimes it's important to have the person who can be effective rather than a person that can look in a particular way. Sometimes the two go together and sometimes they don't.
Thank you. I've just seen Saida's comment on the chat that women haven't gained true equality. I do agree with that as well.
Thank you. Can I ask Rachel Owusu-Agyei to ask her question?
Thank you for that illuminating lecture, Professor Solanke. You touched on the fact that equality rights are individual in this country, and that is a limiting factor for the progression of race equality in this country. My question is around this particular political moment and the fact that in light of the Black Lives Matter movement, there's been a widespread acknowledgement of racism in the UK and an encouragement for people to educate themselves and invest in literature to understand what racism looks like in the UK. Do you think, you mentioned some action points being utilising existing law in that same individual structure, for instance, for positive action or for the public sector equality duty. Do you think perhaps that it might be a better solution to your public health view of race discrimination in this country to have that critical mass of education amongst people who make decisions, to be familiar with the language of race and being able to discuss racism? That might lead to better solutions to what is a pandemic of racism in the UK than utilising existing individual laws.
Yes, yes, yes. Absolutely. Yes, of course we have to educate ourselves, but as I tried to stress, focusing on the individual and focusing on individuals themselves changing their behaviour isn't enough. That's what we've been doing for the last 50 years. So I think there is absolutely more of a need for not just individual leaders in organisations to educate themselves, but also more of a change in the values and the visions of those institutions that are become more inclusive and that become perhaps braver in using positive action tools to really develop sustainable change in their organisations. So we have to, I think, move beyond thinking about what individuals do for themselves and think more about what institutions can do to enable individuals to develop and to enjoy their individual rights, I suppose. So it really is more of a balance between the two things that I'm promoting, not just abandoning the drive to improve individual rights, but balancing that with a significant improvement of institutional values and norms.
Thank you.
Thank you. I'm going to ask one final question. Joe Schumacher.
Hi, Professor Solanke. Thanks for your lecture. I've listened to everybody's questions, but I would like to ask one from a different perspective, from a litigation perspective. Do you think that a barrier to equality from a colour perspective could be supported more from a legal aid perspective to support more claims going to court when there has been a clear discrimination or even a not so clear one? And could a barrier be wealth in that instance?
So I'm sure that wealth is a barrier across the board, but that might be particularly pertinent in relation to discrimination cases. But I think more a barrier in relation to race cases is the likelihood of winning. I think that if you look at the tribunal statistics in terms of the cases brought and cases won, the number of cases brought for race are low, and the number of cases won are even lower. And there could be any number of reasons for that, which can include wealth, or which can just include the confidence in taking on your organization. As I said during my talk, it's a very difficult thing to pursue a race discrimination case, and these are cases that take a long time. You're unlikely to have the evidence that you need to take on your organization. It can destroy your livelihood, it can destroy your health. It's very challenging to bring a race case, and you won't necessarily have an informal support network to carry you through that. So legal aid will definitely help, but I also think there perhaps needs to be more understanding on the bench of what race cases involve. And I think that would make a difference to individuals having the confidence to bring race cases, and when they win them, having the confidence to get on with the rest of their lives.
Thank you. Yes.
Well, thank you very much, Iyiola Solanke, for your fascinating talk this evening, and thank you for all the questions that have been asked so far. I should say that when I was interviewed to be a judge, I was asked the following question as part of my interview, which was why I thought that some minority groups had achieved legislative protection in the UK earlier than others. And I wish I'd had Iyiola Solanke by my side at the time, which was a question that came out of the blue. But I also wish that what I'd said was that the real question was not how they achieved or why they achieved it earlier than others, but how effective it had been. And I think that that's a question that we've had looked at this evening by Professor Solanke, and I think we should all be asking ourselves, how effective is the legislation that we have, and how can it be made more effective? So thank you all very much for attending and for your very interesting questions. Thank you.